My best side. Okay. I will shout as best I can, but if you can't hear me, you may be actually better off. But if you do want to hear me, let me know and I'll try to articulate better. Well, thank you very much for having me here again, even if I am a fill-in. But I know you remember every word I said before. There probably won't be a lot new, and one of the reasons is that civil rights cases and discrimination cases and employment cases are mostly cases that come out of statutes. You know, the difference between common law cases, like cases that have been around forever, and then cases that come out of laws that get passed either by the state or by the feds. Most of the cases I deal with, most of the kind of claims I deal with are come out of statutes. And so if there's no new laws that get passed, the law pretty much stays where it's been. And really, there hasn't been any new big employment laws passed since the early 90s. The Congress hasn't changed, and Congress and the President have really not been able to get together on most things for the last 20 years, so things have pretty much stayed the same. Discrimination laws, family medical leave laws, wage and hour laws, they've really pretty much stayed the same, and so things have pretty much stayed as they have. But let me bring you up to date on some of the things, especially for you who are new. One thing I like to tell everybody, and I tell this to lawyers because very, very few lawyers actually do employment cases or civil rights claims. The statute of limitation is very short. So I suggest whenever somebody comes into your office, and I know a lot of you probably don't do employment law, but you probably hear all kinds of cases, or maybe people even come up to you in church or wherever and ask you that they have an employment law case. Be aware that they are about the shortest statute of limitations there are. Discrimination cases generally are a 180-day statute of limitations, which is much shorter than probably the types of cases that people you work with are used to. A Mobile County Personnel Board case, if a person works for the county and gets terminated, they only have 5 days to file an appeal with the Mobile County Personnel Board. If a person has a union complaint, they often have only 5 days. If you get terminated because you were a whistleblower because of safety violations at the job, if you've got somebody who works at Austal or at AMNS or something like that, and they feel like they got fired because they complained to somebody that there was a dangerous working condition, 30 days. So they're very, 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 very short, and it's really important that even before you give it much thought, somebody let somebody know that something's happened so you can at least take a look at it and see if it's something that needs to get filed. Other types of laws that I do, civil rights laws, often have older statute, longer, like 2 years, 4 years, and more. But it's important to remember that those will be gone before you know it, and it's really important to get on top of it before. When it comes to employment, and I'm sure you've all heard this before, Alabama, like every state in the country, is an at-will employment. That means anybody in this country can quit their job any day they want, and anybody can be fired any day the employer wants. There's no slavery. There's no law that can require a person to keep working, and therefore there's no law that requires the employer to keep somebody. Now, there are a few exceptions to that. People who have a union contract have a right to a job and can't be terminated unless there's a good reason. Baseball players and movie stars probably have their own contracts, that they signed that said they get to work for a certain amount of time. But most of us, from people who sweep the floor at Hardee's all the way up to bank presidents and doctors, well, maybe not all doctors, but generally work at the pleasure of their employer. And the day the company, for whatever reason they want, good, bad, or awful, decides that they don't want that person working there anymore, generally the rule is they're gone. So are they entitled to a termination notice? No. Are they entitled to know the reasons they're terminated? Nope. Are they entitled to a severance? Not unless there's some kind of severance agreement. So it's pretty cold hard facts. It's the law of the jungle when it comes to employment. And a lot of the things that Michelle and I are doing when people call is, can we find an exception to the rule for this person? Can we find a statute where the person was protected? In those very, very rare cases, can we find that there was an employment agreement? Like maybe somebody was hired and they were given a letter saying, welcome, happy to have you here. Here's the terms of your agreement. Here's how much you're going to be paid. Maybe in there it might say how long they get to work or the reasons they won't be terminated, but those are often far and few between, and they're generally for nice professional jobs. Maybe a person's going to be a bank president, or doctors also often have those agreements. Professors may have those types of agreements. But that's the first thing that Michelle and I have to look for is there something in writing, or is there some kind of protection that they wouldn't have otherwise? Unions are one of the few exceptions. If you have a union contract, that's one of the great benefits of working for a union. You have an agreement. It is a legal contract, and it says, here's how much we're going to pay our workers, here's the conditions they're going to work on, and number one, for me, is you can't terminate this person unless there is a good, sufficient reason. So those are the things we try to look at. The exceptions in the law are generally come down to discrimination laws. And the discrimination law, the federal discrimination, there's no state discrimination law, there's only federal discrimination laws. And that what they say is, okay, if the person got terminated because of their gender, because of their race, because of their age, because of their national origin, because of their disability, or because of their religion, that is against the law. So there doesn't have to be a contract, doesn't have to be anything. That's the law, and it's limited to only employers that have 15 employees. So it's not going to handle the tiny little restaurant that just has mom and pop and a few folks working there. But otherwise, it covers that, and that's the one that has 180-day statute of limitations. So that's the one we have to look at very quickly. Cases like that generally get brought in federal court. And then the other laws that Michelle and I look at a lot are Family Medical Leave Act. That's the law that says a person, if they take sick leave and they're off for a few days, they can't be terminated. Now, many countries in Europe go a step further. They not only say that you can't be terminated for taking sick leave, but you actually get paid for it. And many countries actually have very generous benefits. I think in Scandinavia, you can get a year off paid at like 60% to have a child, and that's male and female. But in this country, the best you can do is to have your job protected. That's not being paid for or getting sick leave or anything like that. That simply means that if you're on Family Medical Leave Act, if you're covered, you can't be terminated for taking 12 weeks of sick leave. And then the other one we deal with is the wage and hour laws. And the wage and hour laws, ones that have been around since Franklin Delano Roosevelt was president back in the 30s, they say that you have to be paid minimum wage at least, which is $7.25 an hour, and for any time you work over 40 hours a week, you've got to get time and a half. Whether it's $10 an hour or $20 an hour or $30 an hour, you've got to get that plus half more again, so get time and a half, 1.5 times your regular salary. Now there's a lot of exceptions to that, and that changes almost with every Congress and every president, but it doesn't cover administrative folks and professional folks and executives. So there's a lot of exceptions to it, and there's more exceptions than there are even rules. So that's something you really have to get someone who's in the field to talk to you about. It's one of the exceptions, ironically, is for IT people, and I don't know how that exception happened, but people who are and I'm not sure the specifics to it, but if you're only in IT, there's an exception to that rule, and there's no protection whatsoever. Waiters and waitresses have a different minimum wage. Their minimum wage is $13 an hour, but that assumes that they'll be getting tips, and the tips must bring them up to minimum wage. So it's still a minimum wage, but the employer is only responsible for the sub-minimum wage. The other thing I do a lot of is police misconduct and inmate case. I do all kinds of civil rights cases, housing discrimination and public accommodation discrimination and things like that. And you don't see a lot of those cases. But I also do police misconduct and inmate rights cases, and we see more and more of those, especially as more things, now that cameras are everywhere, more people are aware of situations where a person may be arrested or hurt by the police or by a deputy and feel that their rights were misused, and so we look at those, as well as inmates who may have had problems, have been hurt, or not gotten medical treatment. As you can imagine, like a lot of the cases Michelle and I work on, inmates cases and police misconduct cases generally don't have a lot of sympathy because people, for good reason, generally sympathize with law enforcement. And there's reasons. I mean, those folks are out there like soldiers putting their lives on the line every day. So when we take those cases, we have to make sure that it's pretty egregious because we know that the jury is normally going to sympathize with law enforcement. When you see cases like that, the rule of thumb, like a lot of things, I think, your gut feeling is generally going to be correct. If a person comes to you and they might feel like their feelings were hurt, those cases are probably not going to go far. But you may have all met someone or known someone who really felt that they may have even been guilty of a crime, but once they got into jail, they were misused, or they had an illness that wasn't treated, or got held longer, or out if they're out in the field and they've been arrested by the police or treated by the police in a way that hurt themselves or the police were excessive. There are protections to that, and so we look at those very closely and see, number one, can we prove it? And number two, do we think that it's so bad that a jury is willing to say, you know what, I'm a strong believer in law enforcement, but I also think this was a step too far. And there are rogue cops out there who do some nasty things, and that's what we're trying to look for. We also take a look at tenure cases, professors and teachers who have certain more rights, because tenure is kind of like a super union contract. It says after you have a certain number of years on the job, you do have job protection. So we look at those as well. All of these have different ways we proceed. Some cases, like discrimination cases, we first have to go through an agency called the Equal Employment Opportunity Commission. And when there's a public employee terminated, we go through a different agency. Here, it's the Mobile County Personnel Board. So sometimes you can't first go into court. You've got to have an agency or a governmental investigative unit look at it. And that's often pretty good, because they often do a good job looking at it, and they also help us gather the information before we have to decide to file a case. But they can also have very short deadlines, so that's why we have to stay on top of it. Other types of cases we can file right away, inmate cases or police misconduct cases. Those cases generally involve constitutional violations. So that's where we go right back to the Bill of Rights. And as you all know, as I was teaching my scout class last night in the Citizen in the World, Ryan, her son, and my son were in Boy Scout troop up at St. Paul together. The Bill of Rights gives us all certain protections from the government. First Amendment, of course, is freedom of speech, freedom of religion. The Fourth Amendment is the right not to be subjected to excessive force and arrests. So that's the Fourth Amendment we use when police have maybe beat up somebody unnecessarily. The 14th Amendment and the 8th Amendment give people protections when they may be incarcerated and suffer, like if they're in jail and they feel like they've been beat up or hurt, or they haven't gotten sufficient protection. One case that Michelle and I had was a inmate in the Metro Jail who got tasered. Can I tell the story so close to lunch? The taser went into his eyeball, and he was on the 7th step of a step. So the taser knocked him out. He fell 7 steps onto the cement, lost his eye, and broke his head open. So we brought that case as an 8th Amendment case against the officer who overreacted, in our opinion, and went down and picked a jury, but settled it after that. So that's a classic example of an 8th Amendment case where a governmental unit has overstepped. What we felt was overstepped. It's what it should have done. The punishment, it's basically, the 8th Amendment is against cruel and unusual punishments, which back when our country was founded was, we weren't going to put people in the stocks anymore. We weren't going to kill people for jaywalking. So we got to make sure punishment is the punishment fits the crime, I guess is the way we're saying. We're not going to overdo it. And the Eighth Amendment is used in these situations so that inmates or anyone else are not overly punished. If you read the paper, you know that our prison system is absolutely in a shambles. Nobody has a lot of sympathy for inmates, and most people feel they're in prison for good reason. But if you know anybody in the Alabama prison system, or if you read about it, you will find that it is absolutely worst in the country, and it is highly overcrowded, very brutal. It's not easier for the guards either. I mean, we've represented some guards well. It's a terrible situation, and there's a lot of abuse there, and it's hard even to know where to point the finger. So we see a lot of cases come out of the prison system. We see inmates who have not gotten medical care that they should have got and suffered as a result of it, or died, or been subject to brutal conditions because of it. Again, jury appeal, not much. So we have to look at those cases very strongly, but there's no end to the number of letters we get from folks in that situation. What other kinds of things do we do? I guess the ones that you will see the most are discrimination cases, and we see an awful lot of discrimination cases. Some of it is the frustration that employees feel because they get terminated and they don't feel they got terminated for a fair reason. And it's true. I mean, most people would probably say it was unfair why they were terminated, but they still don't have any legal recourse. So they look for the few laws that are available, and sometimes it comes down to they'll say it's discrimination, and we have to make an evaluation. Yes, we'll agree that terminating them for no good reason was awful, but was the motive discrimination? And that can be a very tough thing, and how to prove it can be very tough, because most employers, let's say no employers will say, sorry, I'm terminating you because of your race, or I'm terminating you because you're a female, or things like that. So what we have to do is try to get behind the reasons given and try to determine what the real underlying motive that is. And that is very, very, very difficult. And sometimes it's simply a matter of looking for hints and collateral information and how did they treat people differently. One of the big subparts of gender discrimination, of course, is sex harassment. And there have been some updates on sex harassment, and I'm sure you will have spoken to people who feel like they've been injured by sex harassment. So let me just give you these pointers. Number one, sex harassment can be male on female, and it can be female on male, and it can be female on female, and it can be male on male. In fact, one of the biggest verdicts we ever got was a female on female sex harassment against Walmart about maybe 20 years ago. The big question is, was it harassment? And that means the conduct has to be severe and pervasive. Those are big words for saying severe has got to mean it's got to be bad enough. And pervasive means it's got to be happened enough times. And then it got to show it's because of sex harassment. I'll give you one example of something that was not severe enough. Once we had a client come in, and she worked at a telemarketer. I can't remember who it was, and she said that she was sexually harassed by a co-employee. And I had her describe it, and she said the co-employee came up to her booth once and asked her out. I said, okay. Then what happened? She said, that's it. Well, she was, I think, from a holiness church or something like that. She really, honestly, sincerely believed that was offensive conduct. There's no question about it. I don't doubt her feelings. But it obviously was not severe enough that a court is going to say that is sex harassment, because that's just normal. And let's face it, a lot of relationships begin in the workplace, so we're not going to be throwing out the baby with the bathwater. Now, if he had come up to her every day or twice a day for a month and asked and asked and asked and asked, and every time she said, no, I'm getting myself cut off. If that went on and on and on to the point that she was near absolutely exasperation, it's not so severe, but it's pervasive, meaning it's happening over and over. So at that point, you do have sex harassment. So it's really it's not always going to be black and white. It's going to be a matter of balancing. But if you all have been walking this earth long enough to know what was probably severe and pervasive. So if you see things like that, you're probably right. The question is, do you think a jury is going to feel it's severe and pervasive? And the other thing that's important for us is that we show that the company was aware of it. Because if there's harassment going on in the workplace, but the company had no idea about it, the company is not going to be held responsible for it. So if you have friends or you have anybody who feel that they are being harassed, they can certainly speak to a lawyer, but before the company gets legally responsible for it, it's got to have a chance to be told about it and do something about it. And only that, after the company has basically dropped the ball, do we generally get verdicts in the case. In our Walmart case, I was a little bit nervous about whether our client had put the company on notice. She kind of said she had, and wasn't. So I figured, you know what, the best thing for me to do, because I wanted to make her work environment better. I didn't just want to make her money or me money. So I sent a letter to the company, to Walmart, and I said, X, Y, Z is happening. And you don't leave anything out. This is not something where you try to save something back, for the trial. It doesn't work that way. You got to put the company on notice. And I laid it out, and I got a letter from Walmart's paralegal that said, we'll look into it. And I never heard back from them. So after a while, we sued them, and we won in trial. We won in front of the 11th Circuit. The 11th Circuit is the appeal court. And they were not happy to know that Walmart had blown us off. Company is very, takes a big risk when they just ignore it. Good case for us, and maybe a lesson learned for Walmart. And I think for the most part, especially those who work for employer law firms here, you all know the importance of a company taking complaints seriously. It doesn't mean you have to fine for the employee, but you can't blow that employee off. You've got to do an investigation. Let me leave it at there. If there's anybody that has any specific questions and there's something that's on your mind, let me talk about that. Yeah.
I'm just curious because I know that we send a lot of stuff to you, so you have to filter anyway. How much are you seeing social media play, like either in co-employee issues or sexual harassment, or I don't know about the discrimination thing overall, like where social media is starting to be part of the issue, and do you have to deal with all that?
It's a big deal. And it's a big deal on every shape and form. It's a big deal. It can create the harassment, or it can be a big matter in jury. It can be a big matter in the actually litigating the case. I'm sure you see it in everything you do. My brilliant partner here really made a case for us. We had a lady who has a discrimination case against a fast food place, and I don't know how she do it, but she actually went on social media and found someone that complained against the same store, and actually had taken photos of it and posted it, and actually had our client in the background of the photo. It was like, oh, come on. It was all on Facebook. It was absolutely wonderful. We also have a case of about a woman up in another county who had been harassed. Well, I actually Facebook was a concern. It wasn't part of the. Well, no. She was talking about a certain police officer on Facebook, and the police officer got mad about it and came and arrested her in a Walmart, which you can't do. You can't arrest someone that's violating your First Amendment rights. So that became important, and then after that. There was a lot of stuff on Facebook that went back and forth that demeaned her and hurt her was hurting her reputation. So all that stuff. What's happened really is all those things that used to be word of mouth, people would write a letter to the editor or tell their neighbor. Now they're all going on to social media. So it's really the same law. It's still defamation or harassment or whatever the same laws were, but there's a whole new forum for us to find them and a whole new medium. So it's dangerous. It's like I tell my kids, once you click, it is there forever for everybody. And but you're absolutely right. It's the wave of the future, for good and for ill. Anything else? Well, thank you. I always take this opportunity to tell you that Michelle is the best person and the best person I could ever work with. I think she is my partner. She screens all my cases. She knows law better than I do, and it's a pleasure having her involved with you and you with her. Thank you.
Thank you.